Good day, Crime Talk aficionados. It is the weekend. Yes, we have the weekly recap of all the top stories located for you in one convenient location. I hope you enjoy it. Have a wonderful weekend, and we'll see you Monday on Crime Talk.
Hi, lawyer.
Next on the docket, Richard Allen. He is trying to get rid of the judge again. So the attorneys representing the alleged Delphi murder suspect, Richard Allen, have filed a new motion seeking to remove Special Judge Fran C. Gull from the case. Now, the attorney, Andrew Baldwin and Bradley Rozzi, argued that Judge Gull should be replaced or recuse herself from the proceedings in favor of a different judge. This is the latest motion filed by Allen's defense attorneys. Now, Allen is charged in the connection of the February 2017 death of Abby Williams and Libby German, Monon High Bridge in Delphi, Indiana, hence Delphi murder. Anyway, Baldwin and Rossi were recently reinstated as Allen's defense team. Now, as you may recall, in October, Judge Gull called for them to be removed from the case, citing a social media leak as evidence as a factor. Well, Baldwin and Rossi eventually resigned, although they later contended they did so under pressure from the judge. And then two new attorneys were appointed to represent Allen. Allen's attorneys then fought their dismissal from that case, and that made it all the way to the Indiana Supreme Court. The Supreme Court there in Indiana ultimately decided to reinstate Baldwin and Rossi, although the justices denied a motion to remove Gull from the case. In their latest motion seeking Gull's removal, Baldwin and Rossi, on behalf of their client, questioned Judge Gull's impartiality and ability to oversee the case without being biased. Quote, at every stage from now until the conclusion of this case, the actions and rulings of the court will be scrutinized through the lens of Judge Gull's error in severing Richard Allen's attorney-client relationship with his chosen lawyers, per the motion. In the motion, the attorneys argued that Gull had affected the attorney-client relationship to such an extent that it was unfair. They cited in their motion, this court has already interfered with one of the most sacred concepts in our Constitution, the relationship between the attorney and the client. There can be no dispute that this has occurred. The highest court in the state of Indiana has cemented this fact. Suppose the Indiana Supreme Court concluded that Judge Gull wrongfully denied Richard Allen of his chosen attorneys. Wouldn't an objective person then reasonably believe that she, Judge Frances C. Gull, is biased and prejudiced toward the defendant, Mr. Allen? The attorneys argued that Gull's recusal would remove any sense of impropriety from the case, and the attorneys questioned whether Gull, having removed the attorneys previously, could make rulings without the defense and the public wondering about her impartiality. Now, Gull had said Rozzi and Baldwin acted grossly negligent with the gross incompetence in their defense of their client, so she alleged the attorneys violated the rules of professional conduct. She expressed grave concerns about their ability to defend Mr. Allen. The attorneys contend that Gull violated Allen's constitutional rights to due process. And in a 22-page affidavit supporting the motion, Allen accused Gull of misleading the public during the October 19th proceedings, in which she announced that the attorney had withdrawn from the case. He also claimed Gull interfered with his right to a speedy trial. In addition, Allen took issue with Gull's decision to deny a hearing on the Franks motion concerning the search warrant and other order concerning the ballistic evidence. And that ruling came just a mere 2 days after the Indiana Supreme Court reinstated the previous attorneys, Baldwin and Rossi. So they state in their motion specifically, 2 business days after attorney Rossi and Baldwin were reinstated, Judge Gull issued an order denying a hearing on the Franks motion and denying a motion in limine filed by Rossi and Baldwin regarding the admission of the ballistic evidence by the state. What appears to the defense to be a hastily written opinion lacks any serious legal and factual analysis on such an important issue. Gull's inaction on Allen's mistreatment, the affidavit said, Gull failed in her duty to protect Allen, who alleged mistreatment at the Westville Correctional Facility. Allen was eventually moved to the Wabash Correctional Facility in Carlisle, Indiana, some 233 miles away from the new court-appointed attorneys based in Fort Wayne. Meanwhile, those attorneys filed a motion last week to withdraw from the case given the reinstatement of the original lawyers. Well, Baldwin and Rossi had previously sought to have Allen moved, saying long trips to see him in Westville were proving burdensome for the defense. Now, the court has absolute discretion of Mr. Allen's detention circumstances, it's argued in their motion, and it would be entirely appropriate for the court to err on the side of caution and engage in remedial measures to ensure Mr. Allen is being housed under humane circumstances since he is a pretrial detainee. It would be entirely appropriate for the court to order the detention of Mr. Allen in a facility closer to or near his court-appointed attorneys so that they would have the simple convenience of communicating with him in person and under reasonable conditions without the necessity of lengthy trips each and every time they desire to meet with Mr. Allen to, prepare for his defense. The affidavit goes on and argues that Judge Gull has treated the prosecution more favorably than the defense, and Allen accused Judge Gull of allowing the prosecution to withhold potentially exculpatory evidence for months, the evidence which was central to the September Franks hearing memorandum that the defense had filed. It allegedly involved the investigation into the possible involvement of a third party in the Delphi murders, but Judge Gull never referred to the state or the prosecutor as being grossly negligent or incompetent, as she had alleged Allen's counsel were. Then you have the speedy trial component. Allen argued that Gull had interfered with his right to a speedy trial when she forced the resignation of Rossi and Baldwin during that October 19th closed-door hearing. Allen has intended to file a motion for speedy trial to keep things on track for January of 2024, but Gull prevented this from happening by not allowing Allen to have counsel of his choosing, leading to a delay in his trial. In addition, Allen argued he was again confined to the Westville Correctional Facility, where he'd been experiencing both mental and physical deterioration since October of 2022. Now, it's also alleged that court record violations, the affidavit claims, that Gull shielded certain defense documents and records from the public view in violation of the administrative rules from the Indiana Supreme Court, and this led to a violation of the public access to those records. And because those acts have shielded documents, these actions demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1, which is compliance with the rule, and Rule 2.2, impartiality and fairness under the Judicial Canon of Ethics. Allen alleged further that Judge Gull, following the dismissal of Baldwin and Rossi from the case, struck substantive pleadings from the record demonstrating the court's inability to remain impartial to Allen and displaying judicial conduct that undermines the public confidence in the interdependence or confidence in the independence, integrity, and impartiality of the court. And then Allen said that Judge Gull had failed to engage in some of her administrative duties, failing to approve invoices for Allen's defense lawyers and essentially ignoring their appeals to get paid. Back in May of 2023, invoices for Baldwin hadn't been paid until September of 2023. For example, invoices from Rossi and the affidavit stated were submitted back in May of 2023, but were not authorized for payment until September. The attorneys also requested a transcript from the June 15th, 2023 hearing, which is where the defense asked for Allen to be moved out of Westville to a different facility. While the request was made on August 8th, the affidavit said the attorneys have not received the transcript. The defense even took issue with the July 2023 social media interaction in which a relative of Gull's published a Facebook post concerning a softball tournament held in honor of Abby Williams and Libby German. The girls' grandparents presented the winners with their championship rings, and Gull replied to the post with a comment saying, "Congratulations." While the comments may have appeared to be innocuous on the surface, the affidavit argues that it demonstrated a potential breach of judicial conduct, with Gull choosing to comment on the post, even though she was aware she would be receiving evidentiary and resolving evidentiary issues and procedural disputes in this case with the accused girls' killers. In all, the affidavit laid out a total of 19 supporting arguments for why Allen believes Gull should be recused or be removed from the case. In the meantime, the prosecution filed another document alleging that Allen's attorneys have not turned over discovery evidence or provided the state with a list of expert witnesses they intend to call at trial. So last week we discussed this case in a little more detail. I told you that the judge issued an order on the Franks hearing, which is very weird that she didn't at least set up for oral arguments, for at least some arguments on the issues, and just denied it. And I said, I think this is the judge's way of saying, screw you, attorneys. And I think the attorneys get it. It seems like there seems to be a pattern of this judge, Judge Gull, not liking Mr. Allen's attorney. Why? Because they're zealously representing him. They're coming up with a defense on this case that the judge thinks is going to take time. Well, if the judge is too busy, recuse. Put the guy in legitimate pre-detention hearing, right? Prisons are for people that have been convicted that go to prison. Very rare circumstances that I've ever heard of anybody being held in prison for their safety. And then you have to be in 23-hour lockdown. That's even worse. And yes, it may seem innocuous, but the reality of it is if a judge is commenting on posts where it's in regards to a victim, is that enough? No. The judge is the one that can recuse herself by saying, hey, you know what? Just for the appearance of impropriety or the appearance of fairness, I am going to recuse myself. But now I think she, and for lack of better words, she's in a pissing match with the defense attorneys, and she's not going to give in to a single thing that they're asking for, and she's going to make life miserable. Now, why did they do this motion? Why did they file this affidavit? Basically, the Supreme Court said, hey, defense, we got you. You shouldn't have been kicked off the case. The judge screwed up. But all your other issues, the appropriate course of action is not to go to the Indiana Supreme Court, but you need to raise those issues at the lower court level, and then it's an appellate issue, or once again, they can ask for relief at the Supreme Court level if the court would take it. So that is why they're doing it. They're making the record. They're not pulling any punches whatsoever. And I can tell you, because I've done it recently, I had to file a motion to recuse a federal judge. Once again, judge didn't have any hearing, just basically said, denied. How dare you basically question my ability to be fair and impartial, and let's move along. But the record has been made. But I'm not going to lie, I got a little sense of the judge didn't particularly like me questioning, their integrity, so to speak, that maybe she should have recused herself, but that's the way it is. Our WTF story, Pennsylvania police found a machete and a large kitchen knife next to the beheaded body of a man allegedly murdered by his son. Justin Mohn, M-O-H-N, allegedly decapitated his 68-year-old father, Michael, in their hometown in Pennsylvania. He apparently then held up his dad's head in a YouTube video where he called his dad a traitor and blasted the federal government using some right-wing conspiracy theories. The alleged killer's mother, Denise, called the police on Tuesday to report finding her husband's headless body in the bathroom at their home with a large amount of blood all around him. I wonder how that got there. Yeah, I can imagine. Anyway, police discovered the man's head inside a plastic bag, which had been placed in a cooking pot in the bedroom next door to the bathroom, where they recovered the large knife and the machete. Detectives also retrieved bloody rubber gloves in the first floor bedroom. Now, Moen, a Pennsylvania State graduate, has posted some revolutionary pamphlet titled America's Coming Bloody Revolution, and claimed that Americans would soon have to choose between losing their freedom or killing their family. I guess which one he picked. Well, he killed his family, and now he's going to lose his freedom. I don't think that worked out exactly the way he was planning. Anyway, back in 2020, this pamphlet that he covered claimed that Americans will have to weigh what is worse, allowing themselves to lose freedom and independence or killing their own family members, teachers, coworkers, bosses, judges, elected leaders, and others, older generations. That's according to Mr. Moen, not me. Anyway, Mr. Moen went on to say that family members could be traitors who wish to take away the freedom and independence that comes with America, democracy, and free market capitalism. Well, guess what? Mr. Moen and his quest for freedom, has only wound up in custody, charged with murder in the first degree and abuse of a corpse possession of an instrument of crime with the intent and is being held on no bond. His next court appearance is going to be February 8th. Now, in one of the clips that Mr. Moen posted on YouTube, he also stated that he was the president of the United States, and he blamed the federal government for woke mobs and migrants that he claims are destroying the United States and the globalist community. And he also noted that his dad was a federal employee, so I guess that was kind of his first place he had to begin with. But like I said, I think the attorneys on that one are going to be obviously saying WTF, but they're also going to be saying competency. All right. Everybody's got a secret. Guess who had a secret? Jennifer Crumbley. That's right. The mom of Ethan Crumbley, who killed 4 of his fellow students. She had a secret that she had a boyfriend during all this. Maybe that's why she wasn't being such a great mom. She was a little distracted. Anyway, Jennifer Crumbley took the stand in her own defense, and she attempted to counter the allegations that she was a negligent mother. Now, this all came Thursday before declaring she doesn't believe she is a failure as a parent to her school shooter son. Now, like I said, she took the stand in her own defense, which, let's face it, doesn't happen that often in criminal cases. Frankly, I've won more trials when the defendant doesn't testify. But we'll see if this is enough to raise reasonable doubt. So the prosecutors wrapped up their manslaughter case against her, where she's obviously looking at some 60 years in prison if she is found guilty. And basically, she's being charged over the school shooting of her son. Prosecutors allege that she and her husband, James, who is set to stand trial next month in March, brushed off Ethan's pleas for mental health support, claiming she laughed at him and told James to suck it up. Well, sometimes that's what parents have to do. You know, kids these days, they're a bunch of anxiety-ridden messes. Surprised they get anything done. I had a hearing the other day. I couldn't believe it. The young lady, everything upset her. It made her feel uncomfortable. And I was like, well, okay, this cross-examination, we're going to make you feel real uncomfortable now. And my God, and the problem is everybody caters to this garbage where everybody, has a problem and everything is the greatest concern. Think about it, ladies and gentlemen. Are our problems that different other than we have more creature comforts than people did 100 years ago? Come on. Anyway, Crumbley had to counter one of the text exchanges shown to the court where Ethan texted his mom over his paranoid belief a ghost was haunting him. And when she didn't respond, he said, "Can you at least text back?" Now, Crumbley denied ever believing her son was dangerous and claimed her son's text messages were often sarcastic and he would fool around. She insisted that Ethan, who is obviously now serving life in prison without the possibility of parole, could go to her with anything, hours after breaking down in tears as her son's final diary's entries were revealed. The diary entries appeared to oppose her statement that they were close, as Ethan wrote that my parents won't listen to me about help or a therapist, and I have zero help for my mental problems, and it's causing me to shoot the effing school. I don't know, being a bad parent, we're going to make that criminal? I'm telling you, be careful, ladies and gentlemen. Be careful. Now, Ms. Crumbley's claims that they were close family just a few days after her extramarital affair was exposed in court. As prosecutors argued, she was a little too focused on her romantic interlude with a fire captain rather than her disturbed son. Now, much of Crumbley's opening testimony centered on her family relationship, as prosecutors alleged that Ethan's cries for help were ignored by his parents and even mocked as he cried for help. There was a text that said, "My mom laughed when I told her." Ethan texted to a friend in March of 2021, around 7 months before shooting, that he would have called 911 about voices in his head, but he didn't want to anger his parents. Well, Jennifer Crumbley denied ever laughing at her son's struggles and said he never once brought up hearing voices. However, she admitted he lived a lonely lifestyle without many friends. Oh my God, a teenage boy without a bunch of friends? Anxiety? Oh my God. Isn't that every teenage kid just about these days? She said he, barely brushed his teeth and spent most of his time in the room. There was also a couple times where Ethan had expressed anxiety over taking tests. Oh my God, a teenager. with anxiety, test anxiety. I know adults that get test anxiety. They probably text their husband or spouse about it. Do you think that if they go and shoot someplace up that they should hold that person responsible that they texted that to? I disagree. I don't think so. I know some people disagree with me on this. I just don't get it. Anyway, he had anxiety about what he was going to do after high school, whether it was a college, maybe military. So he expressed those concerns, but not to a level where I felt I needed to get a psychiatrist for mental health professionals. Like I said, that's normal teenage stuff. If anyone's ever raised a teenager, they have all those anxieties. Heck, I have anxieties of not knowing what I'm going to do when I grow up. Seriously, ladies and gentlemen, this is the stuff that teenagers do. And when teenagers go off and do terrible, terrible things, they should be held responsible for it. And unless the parents said, hey, today's the day, you're going to go shoot up that place really good, do good. Unless they said that, it shouldn't be criminal. But hey, that's just me. Let me know in the comments below if you think I am wrong. That's okay. As it relates to the issues of school life, came under scrutiny because of the day of the school shooting. He was caught by a teacher drawing disturbing images of murders and shooting on his homework. Despite writing the "Thoughts Won't Stop, Help Me," both of the parents declined to take him home and left him at school, where he, unbeknownst to them, had the 9mm handgun secretly stashed in the backpack. The key word being unbeknownst to them, secretly stashed, ladies and gentlemen. Now, as her testimony turned to the day of the shooting, she said she had a feeling something was wrong and her son because he texted, "I love you," right after the meeting that morning, which she found to be abnormal. Let's face it, a lot of teenagers don't text that to their parents, right? Anyway, after realizing that the gun and bullets were not at the home, once the reports of a shooting had started, Crumbley said she feared that her son was involved, but admitted her main fear was that he would commit suicide as well. She texted Ethan, "Don't do it," but she said she wasn't referring to the shooting, but that she didn't want him to turn the gun on himself. "I didn't believe that he'd ever shot anybody. That was gunfire," she added. So we'll see. Jury will be getting it soon, and we'll see how things go for Miss Crumbley. I wonder if the firefighter was sitting in the courtroom today for her. I wonder what her husband thought about that. Oh, telling you, undeniable truth. Everybody's got a secret. All right, a prosecutor on the Chad Daybell case is stepping down. Ah, yes, Rachel Smith. Remember, she was the special Madison County and Fremont County prosecuting attorney from Missouri because she had all this death penalty experience. And she was brought in for the Lori Vallow and Chad Daybell murder case. She's going to be leaving the case at the end of February. Now, like I said, she was brought in, remember, a veteran homicide prosecutor who had assisted prosecutors since March of 2021. Now, Chad Daybell's trial is beginning on April 1st there in the Ada County Courthouse. Now, I'll be honest with you. I really don't know what Rachel Smith has done in this particular case. I don't know if she was working behind the scenes, but frankly, I don't have any recollection of her taking a single witness in the Lori Vallow trial whatsoever. I don't know. Maybe the people of Fremont and Madison County down there should be asking their prosecutors why they had to pay this attorney to do what apparently they were able to do just fine. Don't worry, it's just about the money. And it would have saved a lot of less trouble as it related to the litigation issues. And remember, the defense attorneys were always trying to get her off. Now, she was admitted pro hoc vice, which just simply means she's not licensed in Idaho, but that she was granted permission by the court to participate in the proceedings as long as one of the other attorneys was there. I don't think she did anything. I don't think she ever argued a single motion in court. Kind of a waste of money, in my humble opinion.